Hello, everyone, and welcome to a live stream with Uncivil Law. I am Uncivil Law himself, and I'm very happy to be here from my new digs in Austin. For those of you who've been keeping track, I moved this past weekend from one part of Austin to another, and I'm in my new digs and all set up, and that is fun and exciting, so I'm all excited about that. Let's go over some of the stories we'll be talking about tonight. We're going to talk about Pat Mcgrath. Pat Mcgrath is a beauty person who has beauty line brands, sells beauty products, and she is suing basically everyone for use of terms such as sublime and divine. She believes she owns these marks in the literal sense, and she's suing everyone in sight. We're going to talk a little bit about her. We're going to be talking about an influencer who is getting spanked by Texas for all kinds of problems, and we're going to be talking about the Duggars, who showed up to a wedding in violation of an apparent court order. So all that stuff is the things we will be covering today on the channel, just as a way of checking in. How is everyone doing today? Is everyone feeling wonderful and good? I hope so, because I'm feeling very positive myself right now, and I hope you're having just a fantastic day as well. Okay, let's go ahead and get started with this. One second, please. Okay, here we go. No, that's the wrong person. Okay. Okay. Well, I'll just do this. Yeah. So, let's get started now with the issue on the trademark issue. Okay. So this was partially inspired by another YouTuber who I have tagged in the description below and wants to know some basic principles of trademark law. Well, I'm happy to help. She wants to know, when can you own a word? And that's a reasonable question. When can you own a word or a phrase, or for that matter, what else can you own? Can you own a color? Can you own other things? So what can you own and what can't you own in terms of trademark? Okay, so first of all, what is a trademark? Well, in basic principle, a trademark is a mark used in trade. Its primary purpose is to identify the origin of the goods. Its primary purpose is to indicate to the consumer where this product came from. So if you see a John Deere green or you see Tiffany blue, you know what company that is, because those companies have marks associated with those particular colors in that particular trade. It doesn't mean that you can't use those colors. Personally, you can paint your house any color you want, but you can't use it in a competing business in trade, right? So that's the deal. And this also goes for names as well. So when, or just any, yeah, a company name. So when can you own a company name and when can't you? Or when can you own a word? Let's go with that. When can you own a word as a company? That's a good place to start. All right, so let's go through our trademark hierarchy. All right, from least protected to most protected in the trademark hierarchy. Are you ready? I sure am. We start out at generic, where there is no protection of any kind. Anyone can use the word. It is open to anyone to use. And terms can fall into generic use if they're not sufficiently protected, which is why some companies get very upset about this. Words that used to belong to some people include aspirin, escalator, and linoleum, among other examples. Those used to be brand names. They are no longer brand names. They have become genericide, as we like to say in law. So generic is your baseline minimum, no protection, anyone can use the term, go nuts. All right, so next up the list is the descriptive, right? Your word is describing the thing that it is. So, you could have Tom's Auto Shop for an auto shop, or you could have just something else that would just be descriptive of what it is. And now with descriptive, you can't get trademark protection unless you get secondary you get secondary support. So you have to show general acceptance from a wide swath of the public. So you have to show that it takes on a secondary meaning that's not not innately obvious. So you have a term that seems descriptive. If you want protection for that, you're going to have to show that it has this secondary meaning, which basically shows that a wide swath of the community would recognize that name as belonging to you and not to someone else. That's the descriptive mark. Next up the list, the suggestive mark. The mark suggests what the company does, but it isn't as bold as descriptive. So you can throw in your own examples here. All right. Next up the list in the hierarchy is the arbitrary. Words that don't make any sense in relation to the company or mark. They are not suggestive, they are not descriptive, they are arbitrary. They mean nothing. Relation to the brand. Best example on point, Apple. Apple's a pretty good example of a arbitrary mark. Apple has no relations to computers at all. There's nothing about computers that suggests apples. There's nothing about apples that suggest computers. That's an arbitrary mark, right? It's just a random word for all practical purposes. It's a random word picked out of a dictionary, applied to something to which it has no earthly right belonging. So Apple's a good example. And then last up of the list, at the very top of the list, is the fantasyful. It is words we invented to describe something. For example, the most famous is probably Kodak, which is a word that was just invented. It didn't exist before that moment, and now it does. It describes the company, Kodak. So there's your hierarchy of trademarks, okay? So what we're looking for on a trademark level in terms of trademark protections, we're trying to figure out where on the trademark hierarchy we are, right? The higher up the trademark hierarchy we go, the more protection we have. The lower we go down the trademark hierarchy, the less protection we have. Now, there's another thing about trademarks that you should bear in mind. Trademarks do not have to be registered with the US government or with anyone for that matter, and you can still use them in trade. A trademark is something that can just exist, in fact, kind of like a copyright for that matter, right? You don't have to register a copyright. As soon as you write a work, it's copyrighted, right? The moment you put it down, it's copyrighted. Now, if you want to sue over that copyright, you have to register, but you don't have to register to get the copyright. Same thing in trademark, although it's a little bit different, and we'll discuss this, right? You don't have to register for the trademark. You can just start using it. This is not true, incidentally, in my primary field of patents. There is no such concept. Also, incidentally, in patents, which also makes it somewhat unique, is there's no state law equivalence. There is in copyright and trademark. There's not much of it floating around, but there is a little bit of state law floating around on trademarks. Well, more so on trademarks, to be honest, and even a little bit on copyright. Most famously, perhaps New York, where there's a little bit of state law still floating around on copyright law, because you can have state level versions of this stuff. Not unlike patents, where it's just a pure federal system. There's no state law equivalent, and you can't just patent yourself. You have to actually get it registered, or it doesn't exist. So, anyways, back to trademarks. You can just use the name in trade. Okay, does that come with a disadvantage? It does. It comes with a disadvantage because if someone else gets their name on the register, you will be limited in how wide you can use your mark by your actual usage, right? So if you get the mark registered on the primary register at the United States Patent and Trademark Office, then your coverage extends to the United States. It extends everywhere. If you don't have your mark registered, it will only extend as far as your trade has in fact in existence gone. Now, the most famous case on this point is a case called Burger King versus Burger King. One of these you've heard about, one of these you haven't, right? There was a company called Burger King who sold burgers out of their burger stand somewhere. I forget the details. It's not really important. And they never registered their trademark. They were in business being Burger King, and they just were doing their Burger King thing, man. It was great. They were Burger King. It was fantastic. Then along comes a different company, a completely different company called Burger King that you have heard about. And this Burger King is the one that you're much more familiar with. So the Burger King that you know / love / hate / whatever sued the small Burger King and said, "Hey, small Burger King, we're on the primary register. You can't do that." And Small Burger King says, yes, we can, because we pre-existed your mark. We can prove it. We existed before you registered. So we have the right to use that name in trade within our jurisdiction. And so Burger King versus Burger King went to the courts and they sided with Burger King. That's a cheap shot. They sided with the small company. They said, yes, you have your permission to use your name, Burger King, within trade, within some set distance of the Burger King store. I forget what it was. Maybe it was 50 miles. I don't remember the details. Not that important. But yes, the Burger King you've never heard about is the only one that can use the term Burger King within 50 miles of their store. And the other Burger King that you have heard about can't use it within 50 miles of that store, because that's how trademark law can work sometimes. How fun and exciting. Okay. So with all that wonderful background in place, now that I've given you a very quick primer on all the things trademark law, let's discuss a little bit about this person, Pat Mcgrath. Okay, so who is Pat Mcgrath? Well, let's consult the PTO. Okay, so here is a summary of all the lawsuits involving Pat Mcgrath. Now, the Patent and Trademark Office is the official register of patents and trademarks, as you know, one would think. So they've already granted certain trademarks, but they're going to take note of any time there's a court case involving the mark until it's resolved. Because if, anyone was curious, they have to keep a register, because maybe someone wants to buy the mark. Maybe someone wants to sell the mark. You can sell the mark to someone else. And they might want to know, wait a second, what are potential liabilities for this mark, right? So the Patent and Trademark Office just keeps a nice little record of any lawsuit as it's pending. And then once it's resolved, they'll do whatever the courts say eventually, right? So they'll strike the mark, modify the mark, whatever, and they don't need to keep a record of it anymore. So these are kind of all in some version of ongoing. And we can see that they're involved in quite a few lawsuits. We've got Jeffree Star Cosmetics as a defendant. We've got Work and Fetish Boutique Collection, because apparently Pat Mcgrath has a real problem with the word fetish in particular. She thinks she owns that word in this respect to, again, it's industry specific, but still, in respect to makeup, she thinks she owns the word fetish. Okay. We see that she's involved in some other lawsuits, Icy Girl Touring and Licensing, AC Trance, and so forth and so on. So, and then they show all the marks that are in contention over here on the right-hand side. Jana Sheen Jackson, AC Trance, Pharmacist International, and they show all the marks that are being fought over. So they show the exact mark, the exact serial number of the mark that is in dispute or is being fought over or otherwise involved. You can see mark obsession, dark obsession, things like that. Mark obsession, inspiration, addiction, various serial numbers for various registrations, and so forth and so on. Okay, so that's what's going on. All right, so now we have to have a little bit of discussion about, so we see that this person is fairly prolific as a lawsuit person. They're filing a lot of lawsuits against a lot of companies. Against, it seems, the words fetish, sublime, and trance apparently is in there somewhere, and some other words. So in order to discuss what's going on here, let's look at least one pending court case that's attempting to clear this up. All right, so let's look at this lawsuit that's existing. This is a lawsuit that's currently existing from Amorous, a Delaware corporation, and Clean Beauty Collaborative versus Pat Mcgrath, and a New York corporation. And you see the first thing in here is declaratory judgment of non-infringement, right? So what has happened here? Well, what has happened here is that Clean Beauty Collaborative and Amorous Inc. have gotten a cease and desist letter, right? They've gotten a cease and desist letter that says, hey, you, stop doing this thing. Cease and desist letters have some actual legal consequence, by the way, just in case you were curious, right? If I send a cease and desist letter to someone, saying, hey, stop doing this or we're going to sue you, one of the things they can do is say, no, we're going to sue you, right? We're suing you for declaratory relief. Now, you can't just sue someone willy-nilly, right? Because you have to have standing. We've discussed this, right? You have to have a case or controversy. So there has to be an ongoing dispute. So you can't just sue people at random. But when they send you a letter in the mail and say, hey, if you don't stop doing this thing, I am going to sue you. And you're like, well, I'm not going to stop doing the thing. So that seems like an imminent threat to me. So I'm going to turn right around and I'm going to sue you. That's what declaratory relief is, right? I'm asking the court to declare that I'm in the right. Right. And if you were the other way around, you would ask for declaratory relief that you're in the right. But we see this is Amherst versus Pat. So that's what happened in this particular one. If Pat was suing, she'd ask for declaratory relief, among other things, saying, yeah, she wants to be declared that she's in the right. But here it's a defensive action, right? It's a defensive action brought as an original complaint as the plaintiff, if that makes sense. And this law allows you to do that for exactly this reason. All right. And then there's some other stuff about unfair competition, blah, blah, blah. But, it doesn't matter for the purpose of our exercise. So we'll skip. All right. So let's discuss what is going on in this lawsuit and whether or not it can bring us any enlightenment. Amherst is a leading synthetic, by the way, as always, just, by way of explanation, this is a lawsuit written by Amherst. So all things in here should be assumed to be true, but also assumed to be very flattering and one-sided. So if there are bad facts or harmful facts, you wouldn't expect to see them here. So just remember to keep a bit of skepticism hat on. All right, and then they get to say nice things about themselves in their own lawsuit, because of course they do. They're a leading synthetic biotechnology company, blah, blah, blah. CBC owns Rose Inc. and through its Rose Inc. brand offers a cosmetic blush named Blush Divine Radiant Cheek and Lip Color, the Rose Blush. On September the 14th of 2021, legal counsel for PMC sent Rose customer support a legal matter. The latter is addressed to Amherst. In this letter, PMC referenced what it termed the Pat Mcgrath family of divine marks, and further alleged the names that Divine Rose, Divine Skin, and Divine Blush had become associated exclusively with Pat Mcgrath in the cosmetics industry. Yeah, that's one of those things where you want to show some proof, right? Because, the rose, skin, blush, blush and skin are just generic. That's, and divine, it's kind of, I don't know what that is. It's probably descriptive, and a lot of people use the mark. A lot of people call their stuff divine. In the makeup industry, probably not too surprising. So even assuming it was trademarkable, it's probably not trademarkable by her, because I doubt she's the first widespread use of it. I have a noticeable echo? Well, yeah, because I'm in a new room and I haven't done the sound treatment issue. Well, yeah, I have to, the only way for me to fix that issue is for me to stop the stream completely, and I'll have to fix it in the future. I did fix the sync delay though. So I got that going for me, because there was a 300 sync delay between the video and audio. So I did fix the sync delay so that it's now the words and the sounds are synced. So yay. Anyways, carrying on. Yeah, one of my audio tools, one of my audio processing tools I have is a de-echo. And obviously I had it tuned for the room I used to be in. And now I'm in a different room. So the de-echo isn't quite tuned properly. So now I have to go back and retune it for this room, as one does. So we'll get there. Anyways, going back. On information belief, the September letters reference to Divine Rose, Divine Skin, and Divine Blush, individually or collectively, is not a reference to any individual or collection registered trademarks. So they're saying it's not a registered trademark, so there's that. And even if they were, the Patent and Trademark Office would almost certainly require them to disclaim the words skin and probably divine individually. Like you can have a now this is another little thing of trademark law, right? You can have generic words in there, and you can combine generic words and make them non-generic. So divine is probably generic. Skin is probably generic. Is divine skin necessarily generic? No. As a combined phrase, no. Not necessarily. I'm not saying it's not. I'm just saying it's not necessarily. Just because the two components are generic does not mean that the combination is necessarily generic. So you will see all the time from the trademark office, all the time, they will make you disclaim part of the mark if they think part of it is generic. Or yeah, so they say like you have claimed the entire phrase, but not this part of it individually. So just a little FYI, a little bit of baseball about that. Okay. The September letter demanded that Amherst immediately and permanently stop making, importing, selling, offering to sell any cosmetic under divine formative mark. Deliver to us for destruction all existing inventory of current blush divine products and all promotional materials. It's a little unusual for them to ask them to be delivered. Usually they just ask for them to be destroyed, but okay. Identify all third parties who provide the blush divine product to Rose Inc. and have known the location of any molds for such cases or carriers because they want to go after those people, presumably for some sort of contributory infringement or something. Identify the dollar amount of all such blush divine products sold to date worldwide, which would go ultimately to an injury issue. The September letter concluded by asserting that PMC will pursue its rights and remedies to the fullest extent permitted by law without further notice to you. Yeah, that's the kind of thing that when you say in a cease and desist letter, that's the kind of thing when you say that, it's like, yep, I'm going to sue you now because we're not going to do any of those things. We're not going to do any of those things. So how about instead of doing those things, we'll see you in court. And rather than just wait to be sued, we'll sue you first. In response to the letter, counsel for Rose Inc. brand disagreed with PMC's assertion that owned or possessed the marks. No shit, Sherlock, right? And explained its reasons for reaching those conclusions, as lawyers do. For example, the response letter explained that PMC's usage of divine does not meet any legal definition recognizing a family of trademarks, and include citations to case law supporting its conclusion. The response letter also disagrees with PMC's assertion of exclusivity to the phrase divine blush for blush products and explains its reason for reaching its conclusion. For example, the response letter explained that the word divine is a commonly used term in the cosmetic industry. I would think in reference to generic and highly descriptive nature of the word divine in the cosmetic industry. Yeah, so I think generic might be wrong. Descriptive sounds better. Is divine generic? Here's how you can know if a term is generic, or here's a good clue to know if a term is generic. If I use the term, will you know what I'm talking about? Or would a person who has the right understanding? So for example, the most common way this comes up, for example, is brand names and medications versus the actual medication. Any of you who have ever had a prescription drug know that it's most commonly known by two different names. There's the generic name, and then there's the business name or the trade name for it by the company, right? So this is a clean example. So if I use the term like mechanics shop to describe a particular store that does work. So one example might be National Tire and Battery. National Tire and Battery is a company. If I use the term auto shop, would you know what I'm talking about? If I use the term mechanic shop, would you know what I'm talking about? Yes, you would. You know exactly what I'm talking about, right? So the generic describes, it's a substitute for the thing. If I say the big game, do you know what I'm talking about? All right, I'm talking about the Super Bowl, typically, right? There's a reason for that. So you can use the generic, but you understand what you're talking about. The generic describes, okay, here's your mark, divine. Even in the beauty industry, does that term mean anything to you? Does it invoke a particular product, kind of products? Does it suggest lipstick or eyeshadow or face concealer or powder, or what does it suggest? What is it reminiscent of? And now I have to say, I'm not the biggest user of beauty products, although I do put a little powder on my face to help a little bit, so hopefully you enjoy that. But, you know, to me, the term divine doesn't invoke anything. It doesn't suggest anything. It doesn't mean anything to me. Yeah. It's not like calling it makeup, which would be a generic term, right? Divine blush is makeup. Makeup would describe divine blush. If I described it as makeup, you know what I'm talking about. If I use the term lipstick, you know what I'm talking about. That's a generic term. If I use the term eyeshadow, you know what I'm talking about. That's a generic term. What is divine? Doesn't mean anything to me. For example, as an adjective, the word divine means extremely good, unusual, lovely, and of superhuman or surpassing excellent, extremely common in terms of beauty, and particularly cosmetics. One would imagine. I mean, this doesn't take a lot of brain power to believe. The response letter further described hundreds and thousands of products using the words divine in cosmetic and beauty, and concluded that the word divine, as asserted, is incapable of uniquely identifying Pat McGrath as the source identifier of blush or any other product in the industry. And as I stated before, this is the fundamental point of trademark law. The trademark has to be a source identifier. That is its entire point. The name has to tell you the product, or who makes that product, or it's associated with one particular company who makes that kind of product and no other, right? That's the entire point, is source identification. Where's the thing coming from? And divine blush, it doesn't mean anything to me. The response letter closed by indicating if PMC disagrees with our assessment or wish to bring forward additional rights not considered, to contact counsel. We could just sue you. That'd be fun. On November the 12th, the November letter, PMC responded to the response letter by disagreeing with virtually every point. PMC concluded the November letter by asserting that failure to respond will result in Okay, so they sent back a letter in response. Just to let you know what's going on here. They sent them a letter in response telling them, no, we're not going to do any of those things. And now they're getting a letter back from them, all right? So they're getting another letter from the same people, from PMC, from McGrath. They're getting another letter. PMC concludes this letter by saying it will respond by pursuing its rights and remedies to the fullest extent by law. That sounds like a threat to me. So we're going to beat you to the punch. Amherst and CBC together and individually understood the preceding sentence to mean that PMC would file a complaint alleging infringement if its demands were not met. Okay, well, no, we're not going to do that. So I guess we'll see you in court. On December the 17th, PMC sent another letter regarding Rose Inc.'s continued unauthorized use of divine, and stating, we send this final letter to request that Rose engage in meaningful discussion about business resolution. We're not interested in business. We're not interested in a meaningful discussion, right? A meaningful discussion would mean some kind of settlement, presumably, which we're not interested in. We think we have the right to this, and we think you don't. And we're going to sue you and have your marks declared generic, which incidentally is going to burn your ass for every lawsuit you're in, right? Because all those lawsuits where she's poking the bear, poke, right? And maybe some of them settle for harassment cost. If they settle, they settle. But if they get a judgment from this court saying, hey, those terms are generic, all your other lawsuits go poof into the night. So there's a problem. The December letter concluded they will have no choice to sue, blah, blah, blah. On December the 30th, counsel for Amherst and CBC contacted counsel for PMC to engage in meaningful discussion. I'm surprised that they did, to be honest. I'm surprised that they called them, but apparently they did. During the month of January, several discussions took place. Now, it might have been because they were just trying to buy time. So maybe it was purely tactical, right? It's like, well, we need a little bit of time. I mean, I'm not saying this is what happened. I'm just saying it's a possibility. Maybe they need a little time to put together their lawsuit, and they wanted to be the ones to sue. So maybe they call them in good faith, mainly as a mechanism to buy themselves time to put together a lawsuit and, find all these examples and so forth and so on. So, not saying that's what did happen, just saying it's a possibility. During the month of 2020, several discussions took place between the plaintiffs and PMC. Throughout January discussions, however, PMC made clear the only resolution to accept be complete withdrawal of the name, and rejected several alternative resolutions proffered by counsel, such as a coexistence agreement between the parties. Okay, a coexistence agreement. Another thing for trademark law, right? So you can have a coexistence agreement, which basically says we basically agree with each other that neither of our marks infringes on each other. All right, so we can both use the mark in peace. You can use the mark, we can use the mark, we're happy with each other, no problem, right? And you can even do this with registered marks, although I'm not sure why you'd want to, but you could. With a registered mark, you could give someone a coexistence agreement, and then they can use the mark too, which seems inadvisable, but it's a thing that can happen. So, yeah, it's a possibility. Let's go along to get along. Not interested in that. Throughout the January discussion, they understood PMC was alleging trademark infringement. Yeah, obviously. PMC's claim of infringement to withdraw from demands have affected the ability to offer its in-demand products. It therefore affects interstate and foreign commerce. Sure. Obviously. Plaintiffs are not aware of any actual confusion on action and belief. Blah, 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 blah. So PMC does not have a registered trademark. So yeah, what is our claim? What is our basis for suing here? Or is it because we are trying to argue, what is our jurisdiction tie-in? Let's take a look. It's declaratory judgment for the Lanham Act. Okay, that makes sense. All right, I'm fine. All right, never mind. I'm good. All right, and they sent the letter to them. So I think in this case, they can probably get away with suing them in their jurisdiction because they took an overt act inside their territory. But there might be a fight over jurisdiction, but because they sent an overt letter into their jurisdiction saying stop, that might be enough. Incidentally, this happened, perhaps somewhat notably, to the Attorney General of New Jersey, who got successfully sued and is having to defend a case in Texas. Because the Attorney General of Texas, the Attorney General of New Jersey sent a letter to Defense Distributed, which is a Texas-based business, saying, stop make the 3D guns, yo. And that was enough, according to the Fifth Circuit Court of Appeals, which reviewed this on decision, So that was enough. Purposeful act within Texas to create jurisdiction. And now the Attorney General of New Jersey is subject to Texas's court on gun issues. So there's that. So this could be the same thing or similar. Since PMC is not a registered mark and not a single member of the family is a registered mark, the only conceivable rights would be common law rights. This is like state law rights. To divine. No. In the beauty industry, and particularly cosmetics, the word divine is generic, highly descriptive, or merely descriptive term and lacks secondary meaning. Again, by secondary meaning, what we mean specifically is, does a person, even assuming that this is a descriptive term, would members of the general public understand this to be a term that is owned by PMC? Do people in the general, when they say divine makeup, they think, oh, PMC? I'm not buying that. In the beauty industry and elsewhere, divine has, at least for 20 years, likely significantly longer, been used as an adjective. The word also has religious implications that are clearly not applicable here. Nice touch. We're not claiming it's inspired by God. The word divine is a generic term to convey something that's good, blah, blah, blah. Also, for what it's worth, something that's generic in one context can be non-generic in another context. Again, when it comes to trademark law, and I've tried to make this point a couple times, you're looking at the industry, right? You're looking at industry and trademarks existing in particular industries. So it's not like the word Apple, as applied to computers, is inherently arbitrary. It's not inherently arbitrary. The word Apple is not inherently arbitrary. It's arbitrary within the context of a computer company. But you know what is not arbitrary with the context too? Apples. Not arbitrary there. There it's a generic, right? So the term Apple, arbitrary in computers. The term Apple in apples, generic, right? So you can't just say it's one versus the other. Now there is one exception to this, which is for famous marks. Ooh, famous marks, yes. So if your trademark becomes big enough and strong enough and powerful enough, then you get protection in all the categories, right? Because you're a famous mark. So you don't have to individually register for each one of them and maintain all those, because you have to maintain them otherwise. But incidentally, trademarks have to be renewed every 10 years. They don't last forever. So they have to be renewed every 10 years. But if you're a famous mark, then you get in all the categories. Your go-to example here is, of course, McDonald's or Coca-Cola. They get protection in all the categories. So if you want to call your Apple Coca-Cola, no, you can't do that. And if you want to call your Apple McDonald's, first of all, that's really confusing. Second of all, no, you cannot call your Apple McDonald's. No. PMC has not acquired actual distinctiveness for Divine Blush. Yeah. Whatever else they might be able to claim, the use of the name has been there for less than 3 years. There are many, many blush products. That combination of the word divine and blush. I'm there. PMC has not acquired distinctiveness. Alleged PMC family or the asserted divine family. Whatever common law rights they have, which, I mean, again, do exist to some degree, but not much, that may be attributable, the loose collection is insufficient to create a family of rights. Yeah, and even if it would be limited. A family of marks typically requires many years, if not decades, of use before being recognized by the public. True that. PMC's attempt to establish nationwide monopoly in the term divine and assert against other businesses creates a chilling effect. Certainly. There's no likelihood of confusion. Right, so no one is going to confuse our brands. No one is confused, which is another indication of a trademark being a problem. Because remember, the entire fundamental point of trademarks is what? Identification of the source. Source identification is your fundamental point. That is the point. So if the consumer is confused by the mark because they're not sure where it came from, right? So if you open up a burger restaurant and call your burger restaurant McDonald's, customers will be confused. Because they'll be like, even if it looks nothing like a McDonald's, they'll think, well, maybe this is some sort of strange experimental McDonald's, new kind of McDonald's, or an old McDonald's or something, right? They'll be confused. You will confuse the consumer, and you will confuse McDonald's lawyers who will destroy you. But, you know, here there's no confusion because no one is confused. No one thought, oh, geez, I bought the PMC blush, but I really thought it was the rose blush. Or I bought the rose blush, but I really thought it was the PMC blush. No one is confused. There's no likelihood of confusion between these marks, the widespread use of divine, blah, blah, blah. PMC does not have a protectable right in the term divine, and if they had it, does not infringe. Yeah, because it does not deceive the public by confusing the public. It's unlikely to cause confusion, correct? No problem. Plaintiff's use of the phrase blush divine radiant lip and cheek color is not a source identifier. Rather, the source identifier to rose blush is rose ink mark. Right. When we created the term blush divine radiant lip and cheek color, we were not trying to create a source identifier in that phrase. We were not hoping beyond hope that somehow the phrase blush divine radiant and cheek color, people would just say, wow, that's rose ink, man. Oh, that's a rose ink brand name if I ever heard one. Rolls right off the tongue. Use the word this divine in this is not a trademark. True. Use of divine in this format describes it. The use of divine is unlikely to cause problems. Count 1, declaratory relief. Yeah, you can have declaratory relief. No problem. No problem. Now, let's see if they attach some letters to this crap to it. No, unfortunately not on the version I have. I do not have the letters that they sent back and forth, which would be hilarious. But I'm looking at this and I'm like, yeah, this is pretty easy. This is pretty easy. I mean, I know without even thinking about it really hard that Divine is used in all the brands ever. I mean, I know that's true. And I know they don't have a registered mark because of course they don't. And I know that, you know, this is like, this seems pretty easy. So they'll go fight over it for a while, and, you know, that'll be how that proceeds. So hopefully that was all very, very entertaining. How do we like that story? Yeah, Apple Corp versus Apple Computer is an interesting case, right? Because Apple Music, which was distinct from Apple Computer, and then, of course, Apple Music and Apple Computer kind of famously settled by agreeing that Apple Computer would never use the term Apple in music. So, yeah. But then, of course, Apple became so big that they just bought out Apple Music, so it solved the problem. So, yeah, that solved the problem. Okay. Let's take a look at this thing by Brittany Dawn. Brittany Dawn is a fitness influencer. What if you call it McDowell's? No. I think also the arches of McDowell's are confusing. Yeah, confusingly similar. I think that their entire impression is a little confusingly similar. I'm not seeing that one working in a courtroom. Yeah. So, yeah. All right, let's cover this case of Brittany Dawn. All right, so who is Brittany Dawn? Brittany Dawn is a fitness influencer who has been accused by the great state of Texas of scamming people out of hundreds of dollars for a workout plan. Okay. A Dallas-based fitness coach and influencer has found herself at the center of a controversy after fans and followers called her out, allegedly scamming them out of hundreds of dollars for a fitness program that didn't provide what was promised. Uh-oh. Brittany Dawn, who has over 840,000 subscribers combined across social media platforms, has made a living off of fitness programs that she's promoted and sold to thousands of women since 2014. But now her business is being taken down by those same women who says they have yet to receive much of what they receive. Okay, so this is like I give you part of the thing now and I deliver maybe part of it later, but I didn't get it, or what I got later was not what you described to me, or so forth and so on. These kind of things. Yeah. It sounds like where we're going with this. According to her business website, Brittany Dawn Fitness, the influencer who offers personalized food and fitness programs for up to $300, which includes weekly check-ins and email support from Dawn. A Facebook group of over 3,000 people in a YouTube video posted on Feb 5th, however, began to show people who claimed they weren't getting what they paid for. And apparently this is a picture of Brittany Dawn in 2013, 2018. And I'm not 100% sold, personally, on the 2018 version, I have to say. But that's me. It used to take her over 6 weeks to reply to me, Kayla told the news outlet. I can't just imagine her stealing all this money from people. It's not okay. If she promised more than she could deliver, right? A woman featured in YouTuber Cassidy Campbell's video says the plans are not individualized. Complaints processed through the Better Business Bureau address the same issues. The Better Business Bureau is just a voluntary group. I mean, it's a voluntary association. They have no, like, legal power. The worst they can do is, like, kick you out of the club. But, you know, yeah. I purchased 3 online plans from Brittany. The first was a month-long training plan advertised as individualized, when in reality it was the exact same plan every customer receives. Uh-oh. In addition, the plan includes weekly check-ins to ask questions, receive guides, and adjust macronutrients with the promise of a 3-day turnaround. Not only were the responses from her well past the time frame, they also didn't bother to answer any questions. They were generic responses like, doing great, keep going, girl, and the like. Uh-oh. Others have said that beyond Dawn not responding to those looking to guidance from her, the influencer has apparently neglected to reply to many concerns coming from those who purchased her program. In fact, she allegedly deleted all negative comments and even blocked refunds, and even went after... Okay. In a video to her channel, Dawn apologized to followers for being human. We have no objection to you being human. We do have objections to you promising more than you can deliver in commerce. You know, basic principles of contract 101, right? Basic principles of contract 101. I give you money, or we exchange promises. We exchange promises, or we exchange assets of some kind. We exchange consideration of some kind, right? So in this case, what is the consideration? I'm giving you money. Great. You in exchange are giving me a fitness program. You say we'll do these things. You know, it will be weekly check-ins, adjusting my nutrients. It's individualized. None of those things happen. So we got to breach a contract because you didn't deliver on what I gave you the money for. And your breaches were not even commercially reasonable, because sometimes you can get a little bit of slack from the courts, right? So unless your contract is really hyper specialized, if it's just slightly off, right? The contract doesn't, they don't care about really small things unless the contract is such that they should. But like, you know, if you order 1,000 pounds of something and they only deliver 999, unless you can show the thousandth pound was really important, the court's probably not going to care. So like, yeah, I just can't be bothered. So I don't know what to tell you. But yeah, that's probably not an issue here. I ran too fast for one person, she said in the video. It sounds that way. It sounds like you extended yourself beyond your means. At times it got extremely overwhelming. I took on more than I should. I'm fully responsible in sorrow. Well, she owes a lot of people some money back. Sounds to me. You're not the victim here, one person in the video said. The minute you realize you couldn't deliver what you promised, you refund people. End of story. Right? That would be a typical remedy for breach of contract. Right? And we can't get the service because the service is personal. It's to Brittany Dawn. Right? That was what we contracted for. And we can't as a court order personal services performed. We can't order performance on the contract because it's personal services contract and slavery is illegal. So we can't do that. But what we can do is we can order them to give money back, you know, as a remedy for the breach. So, you know, everyone's whole, everyone goes home, you know, life moves on. Dawn didn't immediately reply to the comment. I would just ask all the death threats and other threats at once and for all to be in the end. Yeah, you shouldn't death threat people. That's illegal. And it's also just bad. I would ask for you to please leave my fans and family alone. This is reasonable, good advice. If you have a complaint, sue. Or have the state of Texas sue for you. So that's exactly what we've done. We've got the state of Texas to sue for him. The Attorney General wants a piece of you. So through Ken Paxton, the Attorney General, we complain against Brittany Davis, Brittany Dawn, and Brittany Dawn Fitness for deceptive practices under law. So there we have some discovery stuff. We describe the defendant. We describe jurisdiction, which is no problem. They're a business inside Dallas. So easy enough. Public interest, just to show why the Attorney General's there. Okay. This is trade and commerce. Yes. So here are some allegations, right? Beginning 2014, defendant profited from the sale of an online fitness package to thousands of consumers with the promise of personalized nutritional guidance and individualized fitness coaching. Specifically, defendant's online fitness packages offered macro nutritional assessments and, depending on the plan purchased, daily or weekly email training and one-on-one coaching. Defendant's online nutrition and fitness packages range from $92 for a one-time macro consultation to $300 for 3 months of personalized macros, trainings, and coaching. However, the online nutrition and fitness plans delivered to consumers were not individualized. Defendant also failed to provide the promised coaching and check-ins. Defendants were largely ignored consumer complaints, or if they did respond, only offered partial refunds. In 2019, consumer complaints on social media gained attention, prompting defendant Davis to make a video apologizing. Defendants promptly took the website down. Defendant Brittany Dawn Davis is an influencer and CEO of Brittany Dawn Fitness. Blah, blah, blah. Some more stuff about their history. The BD Want Fit website offered macro consult, which include recalculation of micronutrient. Offered a specialized bridal or bikini competition fitness plan that includes daily text and email check-ins. A self-guide training plan for $45 was also offered, regardless of which nutrition or fitness plan was purchased. An essential component of almost every sale on the website was individualized coaching. The website identified Davis as the individual providing the coaching and support. Right? Said her specifically. This is a problem. If it said from someone on my team or someone on my staff, but it says her. She was described as your coach, your confidant, your biggest supporter and friend. Push you, mold you, and help you to find the person you always wanted to become. The website instructed consumers purchasing fitness plans to fill out a following survey so we can personalize your macros and needs. And says, don't forget, this is just a starting point. I'll be making adjustments as needed throughout your 4 or 12 weeks with me. In addition to the individualized assessment and continued refinement of macronutrients, an essential component of the goods and services was personalized fitness coaching. The weekly interactions between consumers and their coach, Ms. Davis, were to be integral support of individualized support necessary to customize the plan. Defendant repeatedly failed to provide this essential component. Many consumers state they did not receive individualized coaching. One consumer who purchased the 90-day individualized plan received one email back from Davis after the check-in. No further coaching nor adjustments were ever offered or made. Another consumer who had purchased the 90-day plan stopped receiving any contact from Davis after the first 2 weeks. Still, other consumers complained that any responses they did receive, even if initially to detailed check-in, were generic and non-substantive. That's my girl, you're killing it, or you got this, babe. They're given access to a Team Brittany Dawn Facebook group, which serves as a virtualized community. One consumer commented, I thought at first you would create this workout plan based on my needs and want until I referred 2 friends to you, and their plans were the same. Another noted her plan did not take into consideration her workout schedule frequency nor her workout limitations. Since Defendant Davis was not providing individualized coaching in response to daily or weekly check-ins, consumers were not receiving the promised adjustments. Yeah. In addition to lack of coaching or individualized fitness, defendant did not customize each customer's macronutrients at the beginning of the plan. Although customers answered personal questions at the registration about height, weight, goals, and activity level, defendants received generic macronutrient guidelines. One consumer found she and another customer of approximately the same height had a suggested caloric intake differential of only 60 calories, even though one weighed 140 pounds more. I don't know, man. Yeah. Misleading consumers with eating disorders, preying on the weak. Defendant Davis posted on YouTube explaining that she overcame her eating disorder through exercise and healthy eating. In the same social media post, she then offered links to her fitness and nutrition plans. Consumers inferred from the video and links that she had specialized training to address eating disorders. One consumer knows the main reason I chose her out of all coaches was specifically she had advertised herself as an eating disorder soldier. It's incredibly important to me the person I chose had an idea what it likes to deal with an eating disorder. Prior to reaching out for guidance, I had battled with anorexia, and my worst was below 80 pounds. Miss Davis denies that she accepted consumers with eating disorders. However, consumers tell a different story. At least 14 consumers who sought refunds mentioned eating disorders in their complaints. One consumer on their initial survey says, I truly need guidance, help, the right information, support now. I currently have an eating disorder. Horrible body image. I underweight for my height. Miss Davis's response was great. Welcome to the family. Seems like she accepts people with eating disorders. And maybe not so much on adjusting to that. Defendants would proceed to provide cardio exercise and low-calorie macronutrient suggestions that would only be suitable for someone who needs to lose weight, not to put it on. Defendants were charged a shipping fee even though the nutrition and fitness plans were emailed. That's just low. That's just low. Wow, that's a nice touch. They charged a shipping fee for the digital goods. That's just low. And then you have false misleading acts, blah, 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 blah. You get the drill. So yeah, and then they want a trial by jury, which will be hilarious. And here are some things we want. We want defendants to engage in the following things. We want to prevent them from engaging in the following things. Offering or selling any nutrition or fitness plans that include personalized assessments. Offering or selling any nutrition or fitness plan that includes personalized nutrition assessments or modifications. Offering or selling any nutrition or fitness plan that includes individualized one-on-one coaching of any frequency as part of the plan. Offering any nutrition or fitness plan, offering any nutrition plans, selling plans, representing that Brittany Davis has specialized knowledge of and charging a shipping fee. And we also want some civil penalties and stuff like that and blah, blah, blah. And yeah, all that stuff. So yeah, the Attorney General of Texas is having some fun. And it looks like Miss Davis here bit off more than she could chew. And she's going to have to write some checks, assuming she has the money. Which, you know, she probably does, but still. She might have to sell a house or something. I don't know. But it could be problems. So it could be a problem. All right. Let's cover the Duggars. Okay. Here's a picture of the Duggar family at a recent wedding. You can see the Duggar family is quite big, which, you know, I have no particular problem with. If you want a large family and you can support your children, I don't care. I really don't. I really don't care. If you want a large family and you can support them, you know, best of luck. And, you know, what do I care? It's not my decision to make. But, you know, there are some other decisions that may not be theirs to make. Because there's Josh Duggar, who's included in this photograph. Josh Duggar has some problems. Josh Duggar has a guilty verdict relating to some prurient photography that he was engaged in transmitting, and I don't believe he was guilty of the possession, or maybe it was the other way around. Yeah, he was not guilty of the transmitting, but guilty of the possession of the prurient images. Okay, so he's, you know, out on bail, awaiting this, and there's some stipulations of this thing. So I will now read you the stipulations. I'll read you the exchange of the stipulations. All right, so here is the exchange. The court. This is part of the you know, bail, part of the hearing that the court is doing. The court. The next condition is the one I feel strongest about. You can have unlimited contact with your children, so long as their mother is present. However, you're to have no contact with any other minor child, including your minor siblings, nieces, nephews, children of friends, people getting piano lessons. Are we clear? The defendant. Yes, Your Honor. This is not a condition, but a recommendation. I recommend that you govern your actions by thinking about where you might go and who you might encounter. You might not ought to go to birthday parties, family dinners, church activities, these things that might risk violating your condition. Do you understand? Yes, Your Honor. So, you know, there's that. There could be some problems. There could be some problems. So, yeah. So as a natural result of this, of course, not allowed to return to the family home because, of course, there are children there. Not allowed access to the internet, could not live with firearms. And yeah, because we went to this wedding, it might possibly pose a problem. Now, I do want to, of course, caution that this might have been approved by the probation office. So, you know, it's possible at least. So I'm not going to say that, you know, because he's out on basically he's essentially kind of out on probation, kind of, sort of, and he could clear specific events with the probation office. So maybe he cleared it. Maybe it's okay, but We have alerted ourselves to a potential problem in this fact pattern, and I'm having a difficult time believing the probation officer gave him the okay. It's like, you know, when you can't be around your siblings by the court's own words and you're around your siblings and you're at a wedding with nieces and nephews and all the rest of it, I find it difficult to think the probation officer said, yeah, that sounds good to us. But then again, we have seen stranger things on Uncivil Law. So we will at least open our mind to the remote possibility, however remote it might be. So, fun. So that's all the time. All right. So now let me respond to your super chats and other things you have been sending me along the way. Let's see what we got. All right. The bot for super chats still is not capturing super chats. The bot for super chats has failed in its fundamental goals. It is a bad bot for super chats. I will look it up on the back end.
Truth is out there.
Okay, let's see. Studio. Talk amongst yourselves. Let's see. Settings. No, that's not where it is. Monetization. Super chats. Great. The following chats you have given me. $20 from Eric Allen. I didn't get to say it the other day. Your Twitch stream of the game we got to vote on was blast. Love your stuff, man. You know, that was a lot of fun. I think we should play again after the stream. I think we should play another hour of the game. I think we will go over to Twitch and play the game together. I think that will be fun. $5 from Gary Watson. Thank you very much, Gary. $75. Thank you so very, very much, Rogue Accountant. That is an extremely generous super chat from Rogue Accountant. Support your local Uncivil. That is incredibly generous and very, very much appreciated. Thank you very, very much. $5 from Michelle. Appreciate you, Kurt. Thanks for the coverage. $2. Cocaine is one hell of a drug, says Rick James. $1.99 from Russell Warren, outstanding report, and $2 from Anti-Commie. Call it what it is, FBI data. Well, there we are. And let's see if I can see if the bot to capture your just things that you were saying at me. Let's see if that bot is working. No, that bot is busted too. So we're gonna have to do this the hard way, which means I can only scroll so far back into the chat because the bots have completely broken down. So for if anyone wants to ask me a question, and you've asked me a question, then feel free to re-ask me. You can just put the @Uncivil Law at the start of your comment, and I'll be happy to answer questions for a little while. And you can just assume that your question got deleted by the YouTubes and re-ask. So I apologize, but you know we do what we can, and we press on. Yeah, McDowell's, I saw that comment. There are arcs. I don't understand that was a response to. Pat Mcgrath's cosmetics is the wife of Dr. Phil. Okay. Well, I probably should have been able to figure that out. It didn't click in my head, but yeah, that makes sense. Isn't that fraud, charging shipping of emails? It's not exactly fraud, because they know that they're doing it. But it's deceptive business practice because they're not shipping anything. It's not exactly fraud, though, I don't think. Schrumpface says, there's a case with Facebook NDCA court. Judges yelling at Facebook. Facebook lawyers are saying sanctions a lot. Year 4 of pretrial. Can you cover? Covering trials as they're ongoing is a little bit hard, but maybe. G says you're on your own to entertain us tonight. Racket and Joe and pretty much everyone else on stream. See you on Twitch. Oh, Dr. Phil's wife is Robin. Oh, yeah, that's right. Robin McGrath. Yeah, okay, that's right. Okay, yeah, I'm sorry. I was misinformed. That's right. G says you're on your own to entertain us tonight. Rackets and Joe aren't streaming, yeah. Could it be handling? Yeah, but handling of what, right? So it doesn't make any sense. Fred says the Democrats are so scared of the midterms. My son's school board finally is allowing him to school without a mask in New Hampshire. That's interesting. Can Josh Duggar still face a consequence for being at the wedding, even though he's been convicted and awaiting sentencing? Yes. It could influence his sentence. It could influence his sentence. It would be a valid reason for the judge to either increase the category of the offense or to upward depart. It would be a valid reason. So yes, it could impact his sentencing. Assuming it isn't a crime unto itself, which it probably isn't. But it could impact his sentencing for the worse. What is the scope of the Chick-fil-A rescue law for general religion? I don't know what the Chick-fil-A rescue law is, so I can't comment about that. Ezra says, heard on Racket's transcripts aren't evidence. Well, I mean, in the strictest possible sense, that's true. Transcripts aren't evidence. They are reflections of things. So, I mean, transcripts in and of themselves are not evidence. But here it's a statement by a party opponent. And so it counts. So it's not the transcript, although it reflects, it's the transcript itself. The transcript is a reflection of something, right? So it's not that the transcript is the evidence, it's documentation of the evidence. It's a fine distinction. Brian says, the more I watch you and Nick, the more I question if pursuing a PhD in neuroscience was the wrong path, but thanks for a newfound interest in law. 16-Bit Dragon says, why is Josh Duggar out if he's been convicted? That is not atypical. That is not atypical. Why in this particular case that was done, I couldn't say. But it is not atypical for a person to be released pending sentencing. Of course, it's not atypical the other way around. It depends on a whole lot of factors. Usually it depends on the person's likelihood of, repeating offenses, and they're not allowed internet access, and they have to live with, someone who's approved by the court and so forth and so on. So, yeah. And also the time faced is not, how long is he facing? I forget. But yeah, it's up to the courts, court discretion. 314 says, how much to do a cold case dig? My brother versus, I don't know. It depends on a whole lot. The pick was before he was found guilty. He was remanded. Then what are we talking about? Oh, this was a bond when he was awaiting trial? Oh, okay. So he's in jail now. Okay, so I misunderstood. All right, so this is okay. So this happened when he was before trial, while trial was still ongoing. Okay. All right. Okay. Thanks for the correction, Stephanie. So yeah, he's in prison now. This was the time during trial, apparently. Miles Long Johnson says, my cousin was murdered in Tennessee in 2019. The trial finally started this week. I'm very sorry for your loss, and I hope that you're able to get some justice. $5 from Ali says, get ready for climate change. Believe the science, screaming meanies. Uncivil G says, you and Nick going over judge memes as ABC continues their investigation would be hilarious. I'm open to judge memes. Josh Duggar's not out. He went to the wedding while he's out on bond. Okay, yeah, that's fine. 10 to 15 years, it's possible. It's possible, particularly given some of the facts in this case. But I think it's like a 5-year minimum, if memory serves correctly. But yeah, I don't know. We'll see. All right, so I'm going to sign off for now. I hope you've enjoyed this. I'll give you the link for Twitch. That's the link for Twitch. you can come over there and we'll play this crowdsource game. So it's a game where you can vote. It's a game where you can vote in the chat on things that will happen to me in the game and make the game harder or not for me to play. So that's fun. So we'll play that for a little bit. Some guy's name with special letters. Thank you for educating us. As you speak louder, there's some echo. Goes back after you speak softer. I'll fix it. I haven't adjusted that module for the new room, so I have to go back and tweak everything, but I'll fix it. All right, I'm going over to Twitch now. Twitch.com/Uncivil Law. I will see you there in just a moment. Hope all's well. All right, do all the YouTube things. Thanks and bye.